think we can. Good morning, everybody. My name is Margaret Hinkle. I chair the Post Commission. Welcome, members of the public. We're grateful that you have attended, that you are interested in attending our meeting. I will call the meeting to order at this point and begin by taking a roll call of the commissioners. Commissioner Baker? Commissioner Bluestone?
Good morning, I'm here.
Commissioner Calderon?
Good morning, I'm here.
Commissioner Crispin? He's absent. Commissioner Hall?
Good morning, present.
Commissioner Kazarosian?
Morning, present.
Commissioner Luma?
Good morning, President.
Commissioner Talley?
Morning, present.
And Commissioner Baker?
Good morning, present.
Thank you. We have a quorum. With that, I would entertain a motion to approve the minutes of our April 17th, 2025 meeting. Is there such a motion?
I'll make the motion.
Is there a second?
I'll second it.
Thank you. A vote on that motion, please, Commissioner Baker. Commissioner Baker, please. A vote on.
I think he's frozen. Oh, there he is.
Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes,
Commissioner Hall,
Yes.
Commissioner Kazarosian,
Yes,
Commissioner Luma,
Yes.
Commissioner Talley.
Yes,
Thank you. And back to you, Commissioner Baker. I think he is frozen, but that motion is carried. I will now entertain a.
Chair, my connection keeps freezing. If you're able to hear me, that's a yes for me.
Thank you. All right, at this point, I would, we'll take a vote to go into executive session in accordance with Mass General Laws, Chapter 30A, Section 21A1, to discuss the discipline or the dismissal of or the complaints or charges brought against a public officer, employee, or individual under Chapter 30A, Section 21A5, to discuss the investigation of charges of criminal misconduct under the same statute, but Section 21A7 combined with General Laws, Chapter 60, Section 8C2, and to the extent they may be applicable, General Laws, Chapter 6, Sections 168 and 178, to discuss the initiation of preliminary inquiries and initial staff review related to the same and regarding certain criminal offender record information and the same statute, Section 21A7, combined with Section 30A, Sections 22F and G, to discuss and approve the minutes of a prior executive session. We will be taking up matters of reports of preliminary inquiry, a suspension hearing in the matter of Officer Rojas, a division of standards request to enter into a voluntary decertification or suspension agreements in 2 cases, and an update on a preliminary inquiry matter we've already addressed, and a request for approval to conduct preliminary inquiries with regard to certain other cases. Let me take a vote on going into executive session, please. Commissioner Baker?
Yes,
Commissioner Bluestone?
Yes.
Commissioner Calderon?
yes.
Commissioner Hall?
Yes.
Commissioner Kazarosian?
yes.
Commissioner Luma?
Yes.
Commissioner Talley?
yes.
I'm also a yes. Members of the public, we believe that we will definitely be resuming the public portion of the meeting. We believe that that will probably be around 11 o'clock. Jamie, do you want to just indicate to the public how they will know when we will resume? Would you mind just explaining to them?
Yes, there will be a slide up on the screen. I will keep that updated as to when the commissioners are expected back. Commissioners, if you could please leave this webinar and then enter the executive session link, and then I will resend this link to you and you can enter this room again after the executive session.
Thank you. Commissioners, any questions? All right, we will then leave the public meeting for now, and we will follow that other link into the executive session. Thank you. And members of the public, thank you again for attending. We have ended our executive session and are back to the agenda that was distributed before our meeting. I think the next matter is the executive director report.
Thank you, Madam Chair, and good morning, commissioners. I'll share my screen real momentarily just to walk you through some of the activities of last month. If you just give me a minute. Can everybody see that? Thank you to the members of the public who were patiently waited on the fact that we flipped the agenda this morning, given a number of reasons. We are now on the regular part of the agenda, the public part. We remind members of the public and the press that they can always contact us on the information on the screen here if they ever have any questions around any of the matters that post takes. I will begin my report with a brief update regarding today. That's National Peace Officer Memorial Day, May 15. I will follow my update with a quarterly report on complaints and incident reports, and including some high-level information pending certain submissions and complaint metrics. I will also close my report with a brief certification update and discuss the recent opening of the portal for the new certification process. Again, in anticipation of the June 30th deadline. Finally, I will turn it over to Eric Rebello-Pradas, who will give you a recent update regarding our budget, given the recent unveiling of the Senate Ways and Means budget. So, as I mentioned briefly, May 15 is National Peace Officer Memorial Day, which recognizes those law enforcement officers who have lost their lives in the line of duty for the service and protection of others. President Kennedy proclaimed May 15 to be that day 63 years ago. And in fact, the week that includes May 15 is also known as National Police Week, which typically includes a number of different ceremonies throughout the country, and notably, of course, in Washington, D.C., where the National Museum for Law Enforcement is located. In a related topic, I recently read that notwithstanding the hazards of the law enforcement profession that result in fallen officers in the line of duty, the number one cause of death in the law enforcement profession in the country is death by suicide, which speaks to the necessity to address and enhance behavioral health as one of the key priorities for improving law enforcement, and one that every stakeholder has, well, a stake in the matter. I'll move on to complaints and incident reports. Our staff continues to be busy receiving and reviewing information regarding complaints from the public, and also reports from the agencies. The principal intake channel is our public complaint website, and the page is also accessible through our main website. The main intake channel for reports from agencies is, of course, the agency portal, and is in previous months. As I mentioned to you before, we get approximately 34 complaints per week. That's what happened for the month of April. And we get approximately 15 complaints, 15 reports per week submitted per agency. Again, the public complaint number has remained steady in the recent months, although it's still an uptake from last year. For reference, last time I reported these metrics, January of this year, we had an average of 36 public complaints and 19 agency reports per week, which is itself an increase from 2024. At that time, during 2024, we had averages of 30 complaints per week and 10 incident reports per week. Notwithstanding this somewhat variability in weekly averages, a key takeaway, in my opinion, is that the team continues to be very busy week in and week out on the ongoing review and steady inflow of both complaints and reports. I will move on to report recent numbers regarding compliance. As I reported to you before, in November of last year and February of this year, I will highlight the different timeframes we track regarding complaints and incident reports. And again, my intention to continue doing this report is to do it quarterly and compare to prior trends and ensure and incentivize compliance by agencies. So this first chart depicts the open complaints and incident reports that are in the portal and have exceeded the 90-day, I moved on too quick. And they have it exceeded the 90-day closing requirement. The figures in this chart do not include cases or report where the agency has requested and Post has granted an extension. Although we typically grant requests for extensions, Post's questions more and more those extension requests that that significantly exceed 90 days and do not involve a criminal proceeding. In case of those denials, we will continue to report those cases in this chart because those still are overdue. In other words, more than 90 days. So as you can see in this chart, although there does appear to be a significant change in the number of agencies that need to report the completion of cases or closeout complaints, we have from 14 in November and down to 11 to 12. I meant to say there does not appear to be a significant change in the number of agencies. The number of pending incidents is slightly trending higher when compared to November and February, and that is from 18 to 24 to 28. What I find interesting is that agencies that appear with multiple reports are shifting, if you will, from quarter to quarter. This next slide shows the number of cases where the agency has closed the internal affairs investigation, but the discipline is still pending. It may be that the agency has imparted discipline, but they have not yet submitted that information to Post, which I think it's a very minor composition of the cases. Or it could also mean that indeed the discipline is still pending, even though the IA investigation locally has been completed and transmitted to Post. So there is a positive trend from our perspective in this slide when compared to November of last year, which is that there are slightly less cases that fall in this category, although there's still a fair amount of number of cases. We now have 15 agencies with 46 disciplines pending, and Boston continues to be a bit of an outlier here, even though there's some improvement compared to last time. For reference, the state police is a slightly larger department, as I have reported to you in the past, compared to Boston, but they don't have pending cases of discipline. I'll move on to the other slide relative to these incident reports. This slide compares the average number of days where the discipline is pending. This also shows a trend that is not encouraging. The average number of days where the discipline is pending seems to be going up, and not just for Boston, but unfortunately for all agencies. We will continue to look at these cases and reach out to agencies individually to address the reason why discipline lags for so long. complaint. I'll also conclude the disciplinary part portion here, showing you this slide, which shows the total disciplinary records that we have published and the progress that the team has made and continues to make as part of these reviews. We review, redact in some cases where appropriate, and then publish disciplinary records as part of all the information that we gather from agencies and complaints. This slide represents a comparison of the total records that have been published in the recent month by comparing them to prior periods. As a reminder, any given complaint or incident report may contain one or more allegations, so we break down both allegations and complaints. But from the above chart, you can see that the month of April saw a lot of activity in the number of new complaints that we published, as well as the associated allegations. The chart underneath shows a comparison of this month to the same time last year. So as you can see, in general, there has been an important amount of additional records, disciplinary records that we have published. Not quite reflected in these numbers is the fact that we have completed a lot of work in the review of historical disciplinary records, and which is, again, part of the numbers here. So going forward, I expect to see some of these figures increase, but not at the same rate as in the recent month. That is because we have effectively dealt with a backlog of historical records in terms of reviewing, corroborating certain information, and completing what was submitted to post. And so as we go forward, the new records added are those records that come in real time, just as I explained in prior slides. I will close the portion of my report with a brief certification update. We continue to work in anticipation of the July 1 deadline this coming July, when the certification of a large block of officers, approximately 8,000 officers, expires. The team has provided 7 trainings so far. These sessions are attended by people with access to the portal. We explained the new workflow embedded in the portal and have clarified a few questions that have arisen, and agencies continue to seem to be ready to submit all the required information. The area where we receive most questions is around the new process for migrating officer certification expiration date to one that coincides with their birth month, as I have discussed and updated you commissioners in the past. Agencies do recognize that we were in a trajectory anyway, given that every time there is a new academy being graduated, we have officers with a different certification expiration date. And so moving everybody to a certification expiration date that coincides with their birth month is something that smooths out the submit of information and renewal of all those officers throughout the year. So, however, I want to say that agencies, even though they will have to interact with post for certification purposes, certainly throughout the year, we will allow them to submit information on a quarterly basis to try to make those interactions manageable. I would note, though, as I just did a little while ago, that there's already a number of interactions that happen on a regular basis because of academy graduates and other status updates. Okay, so with that, I'll stop here and see if commissioners have any questions or comments before I turn it over to Eric Rebello-Pradas for his finance update. Seeing none, Eric, I know you are online. Do you want me to just keep driving? And
yes, if you wouldn't mind.
You have the floor.
Okay, thank you very much, Enrique. Good morning, everyone. So we updated you on the current fiscal year FY25 financial activity at the last meeting when we presented our Q3 report. So the focus of this meeting or this presentation is going to be for the FY26 budget outlook. Now, last month in April, at the end of April, we did wrap up the House budget with the appropriation remaining unchanged. That was that 8.9 million that the governor had allocated for us, and the House kept it the same amount. When the Senate unveiled their budget last week, it was also the same number, 8.9 million. And their debate is going to begin next Tuesday. We expect after that, between the first and second week, or by the first or second week of June, that the conference committee will be assembled to hash out the budget differences between the House and Senate. At this time, we think it's very, very unlikely that the 8.9 million will change during the Senate budget debate. So therefore, since both numbers are the same in the House and the Senate, the actual appropriation proposed will not be in conference, which means it will not be up for negotiation. So we do believe that the 8.9 million is the number that we will end up with for FY26. Next slide, please. Now, this want to alleviate any potential concerns that we could have for the number. 8.9 million, as I've stated before, is manageable. Now, of course, the final appropriation of 8.9 is $570,000 less than the original request that we had, which was 9.5 million, or it was 6% more. But this doesn't deter from the goal of achieving our full operational status. And the budget appropriation, I want folks to keep in mind that it is an estimate. It is not down to the penny. These are designed as estimates. So it is not unusual to go above or below these particular numbers. But I do want to speak to various assumptions as we look at the $8.9 million number. Next slide, please. As you have heard me say dozens of times already, we are going to see savings in payroll, and we expect that for FY26 as well, between part-time employees as well as estimated salaries for new positions. We have 6 to 7 new positions that we are budgeting for FY26. And then, of course, the annualized to actual payroll differential, where not all positions start July 1st. So we do our best to try and figure out when a position is going to start. But the later in the fiscal year that the position starts, the more savings that you will gain. So we have to always keep that in mind, especially when we're doing some hiring, which we are this fiscal year, next fiscal year, as with this fiscal year. So we know we're going to get some savings there. Also, there's variables in IT spending, especially with the engineering support. Now, subscriptions are, licenses, things of that sort. Those usually stay the same from year to year. They get increased, nominally, 2-3%. But IT support or engineering support doesn't always, that doesn't always materialize every fiscal year. Sometimes we don't need it. And as we've onboarded more technical staff in our IT division, we've needed those types of things less and less. So we could see some savings there as well. Same with the consultant hours. We are still trending every month. We're trending lower and lower for the need for consultant hours. So of course, we don't budget to the penny on those. We try to estimate what we think we're going to use. And of course, we estimate a little bit high because we don't want to be short. But of course, we are seeing more and more savings with regard to our consultant usage, which makes sense because we have more staff. And then finally, we do have options for budget planning. If things did start to get a little bit tight, or if we seem that they're going in more of a severe area, we could force certain hires, postpone certain hires until later in the fiscal year, which would lead to substantial savings. We could also limit some of our internships or fellowships. Of course, a lot of the fellowships we have are paid for by the schools that actually send students over. So there could be some savings there as well, but nothing I think that'll be nothing that will be severe. I really don't see that coming. Next slide, please. And to elaborate that, I wanted to show you that since post inception, its reversions, or the money that is left unspent at the end of the fiscal year, that amount has gotten smaller over time. And as we continue to mature as an agency, we are incrementally closing the gap between budgeted and actual expenses. Now, estimated reversions for the current fiscal year, we are posting at about 638,000. Now, that goes right in line with the range that we've been talking about, which was anywhere between 500,000 and 600,000 for the last few months. To better demonstrate how we can manage our $8.9 million appropriation, what we did was we took the average of our reversions from FY24 and FY25 that you see there, and that comes to about $740,000. We compared it to the original requested estimate that we had of 9.5 million. That's the number we originally requested from the governor's office that we did not get. So when we do that, as you can see here in the last column, that would estimate our projected spending for FY26 to be about $8.8 million, a number that is slightly less than the final appropriation that it looks like we're going to end up with. When you look at it this way, you can actually see why a budget analyst in Ways and Means or A&F would have given us a smaller number anyway. It just goes right along with our trend. I want to further elaborate on this point. Next slide, please. If you now take the FY26, so the final column there all the way to the right, FY26 projected spending figure of 8.8 million, which we just talked about in the prior slide, and you compare it to the final appropriation, which we know we're getting, 8.9 million, which is in the red circle there, the result is a reversion of less than $200,000. That completely coincides with our historical trend analysis on reversions. They get smaller every year. So put another way, the gap shrinks as we achieve full maturity. One of the things that keep in mind too, on the bottom of this particular chart, you'll see those gold numbers. Those are FTEs. And I put those there to illustrate that every year you can see the FTEs have gone up. Again, increased growth. We've always managed to keep that growth going, even though we're not spending to the full amount that has been budgeted. So I just wanted to emphasize that point. So the spending, for a final thought on this, I would say that while the final appropriation, the 8.9 million, is less than we requested, it is entirely reasonable based on the trends that we see with our reversions. And then moreover, the aforementioned assumptions, as well as the small to moderate overall percentage reduction, assures us that the situation is manageable. We will continue with growth. I can also take any questions.
Thank you very much, both Enrique and Eric, and those who have worked with you on presenting the information that you have provided to us. I don't think I see any questions, so I think with that, we move on to the legal update. And I turn to Attorneys Ravitz and Lee.
Thank you. I will turn the floor over to Attorney Lee.
Thank you. Good morning, Madam Chair and Commissioners. I'm just going to start sharing my screen. Let me know if that's not appearing on your screen. So today I'm back before you discussing law enforcement agency certification. I plan to provide an initial overview of a draft standard concerning criminal investigation procedures. Like I said, this is an initial presentation, so I'm merely looking for any feedback and reactions from the commissioners. And so criminal investigation procedures, as you'll recall, comes from the Commission's governing statute, Chapter 6E, Section 5B, which lists the minimum 8 agency certification standards the Commission must develop in consultation with the MPTC. Criminal investigation procedures, as you'll see, is the 4th statutorily listed certification standard. In developing this draft standard, a copy of which is in your meeting packet materials, starting at page 59, I consulted a variety of resources as usual, and those resources include, but are not limited to, materials from the federal government, including the Department of Justice's 2024 report on the Worcester Police Department and the City of Worcester, materials from law enforcement interest groups, reform-focused nonprofits, state-led accreditation and certification programs, agencies in the Commonwealth, including state police, materials from investigative journalism, and specifically here I'm referring to the Globe Spotlight series entitled Snitch City, which concerned the use of confidential informants, as well as public comments. And so those resources identified the following 11 topics as key elements for inclusion in a potential criminal investigation procedure standards. Those elements are key principles, reporting criminal activity, management, investigatory techniques, conflicts of interest, youth, coordinated investigations, criminal intelligence data, victim or witness assistance, communications, and finally, training. And so the key principle here is compliance with the Constitution. And that's because criminal investigations have the potential to significantly impact an individual's civil rights and civil liberties. And so this is, not only important for the individuals who are subjects of criminal investigations, but also for any prosecutions that may follow a criminal investigation, simply because if the Constitution isn't adhered to, evidence may be thrown out and all of a sudden a prosecution may no longer go forward. And the second element is the reporting of criminal activity. And so because an essential component of providing for public safety is investigating criminal activity reported by the public, in addition to those that are observed by officers, an agency's criminal investigation procedure should contain provisions that allow the public to report criminal activity. And so to facilitate and encourage the reporting of criminal activity by the public, the draft standard suggests that an agency's criminal investigation procedures policy should address one, methods by which the public may report criminal activity, and second, conduct the agency and its officers should undertake when the public seeks to report criminal activity. And so with respect to methods, agencies should establish, as is within their means, a variety of easily accessible methods by which individuals may report criminal activity. And so those methods may allow for in-person reporting, meaning at the agency, virtual reporting, such as over the phone, which could potentially include text messages, and also reporting over the internet, which could look like an email, social media, and or a form on the agency's website. And within that, none of this is exclusive, within that allowing for oral reporting, so an individual coming in, providing an oral statement to an officer, as well as written reporting, so providing a written statement sort of saying that they witnessed XYZ. And second, to reduce barriers to reporting, such as intimidation and language differences, agencies should also allow individuals to report criminal activity anonymously via third party and in languages other than English. And so with respect to agency and officer conduct, to avoid inadvertently deterring and to prohibit retaliation against any individual who seeks to report criminal activity, agencies and officers should be prohibited from certain behaviors. And those behaviors include requiring reports to be made under oath or penalty of perjury, and conducting a criminal background warrant or immigration check of someone who is looking to report criminal activity. And I want to note for the commissioners here that we're not suggesting that agencies and officers should never require statements under oath or conduct checks of these nature. Rather, such behavior should be prohibited only when there's no independent justification beyond the fact that an individual seeks to report or has reported criminal activity. And I'll note for the commissioners that this is a recommendation that came from the Worcester DOJ report. And also, as a matter of best practices with respect to agency and officer conduct, agencies should also allow prospective complainants to review their statements for completeness and accuracy prior to finalizing a report of criminal activity, and accept and screen all reports of criminal activity for the purposes of determining whether to initiate a criminal investigation. And so after a report has come in, the next element says that agencies' criminal investigation procedures policy should address management. And so those the requirements an agency sets with respect to management of a criminal investigation should cover the entirety of the criminal investigation process, from initiation to resolution, and should address topics such as the personnel who are involved in a criminal investigation, so who an investigation is assigned to and who supervises that investigation, internal progress reporting and accountability, recommended time limits, documentation, and case file maintenance. The fourth piece I'd like to address is investigatory techniques. And so agencies should include, as part of this policy, requirements concerning investigatory techniques used in a criminal investigation. And what's listed on your screen here are examples of investigatory techniques that agencies may use and that in particular are require standardization because of the potential for sort of ununiform practice, which can potentially implicate constitutional rights and jeopardize future criminal prosecutions. And so the requirement isn't that you need to conduct certain techniques in XYZ ways. We leave that to the agencies to detail when it's appropriate to use a given technique and the processes that must be followed when using that technique. So again, the commission here isn't saying, here's how you should conduct custodial interrogations. Rather, it's directing agencies to specify how they use custodial interrogations, when to use them, and how to administer them. And so setting these requirements will not only safeguard individual liberties, but as I said, buttress the integrity of any criminal prosecution that may follow. The next element I would like to address is conflicts of interest. To ensure the integrity of a criminal investigation and to promote public confidence in policing, agencies should also include a sub-policy or provision concerning managing conflicts of interest in a criminal investigation. And here, we say that a conflict of interest exists in a criminal investigation when an officer seeks to conduct an investigation, in whole or in part, that involves a member of the officer's family or an individual with whom the officer has a close personal or business relationship. And to prevent and address conflicts of interest, a sub-policy or provision within the agency's criminal investigation procedures policy should address the requirements for reporting and evaluating a potential or actual conflict of interest. Next, that sub-policy or provision should address the management of a confirmed conflict of interest, which includes measures that will be taken to prevent the conflicted officer from interfering with the criminal investigation, such as measures to protect the conflicted officer from accessing any investigative materials, and measures that prevent the conflicted officer and the investigating officer from discussing the investigation that's the source of the conflict, as well as the circumstances under which a criminal investigation needs to be referred out because the agency simply cannot manage the conflict of interest. So for example, if a member of a chief's nuclear family is a subject of a criminal investigation, and because of the power dynamics between a chief and all the other officers within the department, that investigation may need to be referred out to another agency because the original agency here has no way of conducting the investigation without a conflict of interest. The sixth element of the criminal investigation procedure standard concerns youth. Courts, both federal and state, have long recognized that youths are more vulnerable than adults in criminal investigations, particularly in the context of non-custodial interviews and custodial interrogations. And so because of this heightened vulnerability, courts have called on law enforcement to take extra precautions when interviewing and interrogating youth. And so in the Commonwealth, as some of you may be familiar with, those precautions are provided through what's called the interested adult rule. And so the interested adult rule says that for a youth to knowingly and intelligently waive their Miranda rights, meaning their Fifth Amendment right against self-incrimination and their Sixth Amendment right to counsel, there have to be three conditions that are met. And so first, the youth parent or interested adult must be present for the issuance of the youth's Miranda rights. Second, the parent or interested adult must understand the youth's Miranda rights and the consequences of waiving Miranda rights. And third, the parent or interested adult must have the opportunity to explain to the youth the Miranda rights and the significance of waiving their Miranda rights. And so this is with the understanding that parents are probably in a better position than a law enforcement officer to explain Miranda rights and the consequences of waiving it to a youth, so the youth makes a fully informed decision. And so with respect to non-custodial interviews, Massachusetts courts haven't applied the interested adult rule to non-custodial interviews. However, I'd suggest that agencies should, as a matter of best practice, at least provide the youth's parent or interested adult the opportunity to be present for the interview. Of course, presuming that's appropriate and time and circumstances permit. Doing so may be beneficial where youth may not independently understand that non-custodial interviews are voluntary and that they're free to leave if they do not wish to participate in such an interview. And also in the circumstances that non-custodial interview may turn into a custodial interrogation. And so with respect to custodial interrogations, I want to return to the interested adult rule that I previously described. The SJC distinguishes between youths under the age of 14 and youths who are at least 14 when they apply the interested adult rule. So when a youth is under the age of 14, the SJC has held that the youth must actually consult with an interested adult before a valid waiver of their Miranda rights. So in order for that to happen, the parent or interested adult has to be there for the administration of it. They have to understand it, and they have to actually explain it to the youth before the youth can waive their Miranda rights. When you're talking about a youth who's at least 14, the youth only needs the opportunity to consult with an interested adult. They don't have to actually do so. And so it's a little bit different. The youth has to be informed by law enforcement that they have the right to have their parent, and it's up to the youth to invoke it. And so because of the distinction that Massachusetts law has recognized, agencies should be explicit in their instructions to officers on how the interested rule applies and how Miranda rights should be administered to youths under the age of 14 and youths who are at least 14. And so lastly, because youths are more susceptible than adults to threats, intimidation, and coercion, agencies should prohibit officers from engaging in behaviors that are likely to be perceived by youth as threatening, intimidating, or coercive, such as making threats, using profanity, and using deception. The seventh element before you today addresses coordinated investigations. And so to ensure that coordinated criminal investigations are both effective and efficient, a sub-policy or provision concerning coordinated investigations should address when criminal investigations will be coordinated with another body or entity. So not necessarily just another agency, but perhaps also a DA's office, the Attorney General, or the US Attorney. If they do decide to coordinate with another body or entity, deconfliction standards and procedures to make sure that no one is duplicating work that could potentially end up interfering and undermining one agency's work. Management, communications, and also dissemination and sharing of investigative materials, documents, or evidence. The eighth element before you today concerns the collection of criminal intelligence data. Agencies routinely collect criminal intelligence data as a means of conducting criminal investigations and proactively devising policies and strategies to protect the health, safety, and welfare of the public. These collection practices, however, when not standardized, can intrude on someone's privacy, civil rights, and civil liberties, produce flawed analysis, and result in data leaks. And so I apologize for that. Yes, here we go. Apologies for that again. So to preserve the benefits of criminal intelligence data while safeguarding against any potential for abuse and error, agencies should address in a sub-policy or provision concerning criminal intelligence data what data is and is not permissible to collect. I'd suggest that perhaps agencies should limit themselves to collecting data concerning criminal conduct and activity that presents a threat to the public so as not to be overly intrusive. Privacy and security measures that the agency will take to protect such data, including when storing data and disseminating and sharing any data. They should also establish requirements or procedures for the modification, correction, amendment, and destruction of any data, as well as address their agency's participation in an intra-jurisdictional criminal intelligence data sharing system, the two most prominent in the Commonwealth being the Boston Regional Intelligence Center and the Commonwealth Fusion Center. The ninth element before you today concerns victim or witness assistance. And so to foster positive relationships with the public, which encourages the reporting of criminal activity and cooperation in criminal investigations, agency's criminal investigation procedures policy should address victim and witness assistance through a sub-policy or provision. And that sub-policy or provision should direct officers to employ appropriately sensitive tactics and techniques when they engage with victims and witnesses, and to connect victims and witnesses to appropriate support services when appropriate, and to also comply with existing applicable laws, rules, and regulations, such as General Laws Chapter 258B, which is the Commonwealth Victim Bill of Rights, that provides certain rights and services to crime victims and survivors to ensure they have a meaningful role in the criminal justice system. I'll note here that a victim and witness assistance sub-policy or provision nicely complements recent efforts the Commission has undertaken to support individuals who are victims of crime or who have experienced a trauma event related to policing. The Commission's page is available, the URL is available on this slide. And second and last, communications. To encourage transparency and accountability, an agency's criminal investigations procedure should also include a sub-policy or provision concerning communications about criminal investigations, of course, as the agency deems appropriate. And those communications might be with individuals who report criminal activity, the public, and the media. Our last element concerns training to ensure compliance with an agency's criminal investigation procedures policy. Agencies should ensure that all officers are trained in criminal investigation procedures in accordance with all applicable requirements, including those set by the MPTC. And that concludes my presentation. I'm happy to take down my slides if there are any questions or reactions from the commissioners.
Thank you, Annie. I don't think I see any commissioner raising a question now. If I can just ask what communication, if any, you've had with the MPTC as to what you've just provided to us?
Yes. So I've discussed this standard with MPTC staff. However, it hasn't gone before the MPTC as a public body in a public meeting yet. I'm not sure if they plan to do so this month or if it'll be that month. I understand that they're meeting this month on the 21st, so they could potentially discuss it on Wednesday. If not, I would expect them to potentially discuss it in June. And so we don't have their, public body feedback yet. So I can't sort of say where this is going to go, and I, can't necessarily promise a timeline here, but I do expect that I'll be back in the future with their feedback and any resulting revisions.
Thank you. Moving on then to the next item, the policy on information in the National Decertification Index.
Thank you. I will attempt to share my screen. Okay, I assume you can see the screen presentation.
Yes.
Okay. This is a presentation on a proposed policy on information in the National Decertification Index, often referred to as the NDI. And the draft policy is contained in the Commissioner's meeting packet. We will not be asking the Commission to vote on the policy at this meeting, but instead we are just introducing it, summarizing its key aspects, and seeking feedback from commissioners and others with the intent of returning to ask for a vote at a future meeting. Just by way of background, there are several statutes and regulations that provide for consequences where an officer is listed in the NDI. So the officer is not eligible for admission to law enforcement training programs, for appointment or employment in law enforcement, or for certification as a law enforcement officer by the Commission. But jurisdictions can submit to the NDI information that concerns a disciplinary action against an officer that is less severe than decertification. And so then that person would, in a sense, be listed in the NDI. So that raises the question of whether the legislature, the commission believes, intended for such an officer to be subject to all the consequences above. And so the proposed policy would state that the commission understands those statutory and regulatory provisions to apply only where an individual listed in the NDI has been decertified by the commission itself, has had its certification or other authorization revoked by another jurisdiction, in which case the commission would, by statute, be required to decertify the officer anyway, or has been subject to an action by another body that is substantially equivalent to decertification by the commission. However, the policy adds that the information in the NDI can still be taken into account by the commission in other ways, and that law enforcement agencies are still required by an existing commission regulation to report such information that they are aware of in the NDI to the commission, regardless of its nature. And finally, the policy would include a request that those other than the executive director or that person's designee refrain from entering or changing information from the NDI if it relates to any Massachusetts action, any action taken by a Massachusetts entity or any Massachusetts officer. And further request that those other than the executive director or that person's designee bring to the executive director's attention any Massachusetts related information that they believe should or should not be in the NDI. So we welcome feedback on the proposed policy from inside the commission and outside the commission, and we'll take that into account and look forward to returning to the commission for a vote. Are there, I can entertain any questions if the commission chair would like me to do so.
Randy, I'm sorry, I don't mean to go ahead of Commissioner Bluestone here, but who funds the NDI?
It is maintained by the IADLIS, the International Association of Directors of Law Enforcement Standards and Training.
Thank you. Commissioner Bluestone?
Yes, hi, Randy. I'm just wondering, who are the individuals or the agencies that are able to make changes to information that's contained in the NDI?
What we've been told is that the agency that has submitted it, and so I would understand that to include members of IADLIS, but I could return with some more specific information about that if the commission would find it helpful, about exactly what their parameters are for submitting information.
I would appreciate a little bit more information about how that process actually works. That would be very helpful. Thank you.
I don't think there is anything else. So moving on then to the last item on the legal report, guidance regarding the meaning of performance of police duties and functions as used in our commission's governing statutes and regulations.
Okay, thank you. So in the commissioner's meeting packet is a draft document entitled Guidance Regarding the Meaning of Performance of Police Duties and Functions as used in the Post-Commission's governing statutes and regulations. And it is largely intended to capture concepts that were discussed at previous commission meetings when this area was addressed. We will not be asking the commission to vote on this guidance at this meeting. Rather, we are only introducing it, summarizing its key aspects, and seeking feedback from commissioners and others with the intent of returning to ask for a vote at some future meeting. By way of background, the concept of performing police duties and functions is relevant in two ways. First, the definition of law enforcement agency in the commission's governing statute includes a sheriff's department, it says department rather than office, in its performance of police duties and functions. And the definition of law enforcement officer includes any officer of an agency, including the head of the agency, so effectively refers back to the definition of law enforcement agency, as well as a special sheriff appointed pursuant to Chapter 37, Section 4, performing police duties and functions, and a deputy sheriff appointed pursuant to Section 3, performing police duties and functions. Now, the commission previously construed these phrases as referring to the part of the sheriff's office and those sheriffs, deputy sheriffs, and special sheriffs that perform the full range of police duties and functions, including all types of arrests. And there's a second way that this concept of police duties and functions has relevance, and that is that a commission regulation provides that a law enforcement officer, so someone who falls within that definition of law enforcement officer, whether they're working for a sheriff's office or another agency, cannot perform police duties and functions without having an active certification and the legal authority to do so. So the proposed guidance would make clear that performing refers to personally engaging in or supervising or overseeing another's engaging in a certain form of activity. And police duties and functions refers to a list of 7 forms of conduct, provided that a reasonable person would view that conduct as involving an assertion of authority over another individual or entity using or purporting to use law enforcement powers. And those 7 forms are derived from a statute and a Supreme Judicial Court decision interpreting that statute that concern police powers. That list is also substantively very similar to a list of functions based on those same sources that was suggested to the Commission in 2022 when it considered the construction of the scope of Chapter 6E, but that the Commission did not incorporate it into what was finally adopted. Instead, the document referred to the full range of police duties and functions without elaborating further, with the exception of a reference to carrying a weapon. This list, combined with the elaboration on performing that I mentioned a moment ago, is also consistent with a definition of police duties and functions that was recently approved by the MPTC. So here are the 7 forms, again, derived from that statute and that case and consistent with the MPTC and similar to what was proposed previously. Suppressing and preventing disturbances and disorder, dispersing people, entering private premises to suppress breaches of the peace, stopping, arresting, processing, and confining subjects, searching individuals and seizing evidence and contraband, questioning individuals and otherwise investigating, and carrying a weapon. The list does not include merely serving process or transporting prisoners or other persons in custody. Those are things that the SJC identified as things that were not police powers, as that term is used. So taking the above in conjunction with how the Commission has already interpreted the definition of law enforcement officer, the guidance would make clear that the term law enforcement officer extends to sheriffs, special sheriffs, and deputy sheriffs if they personally perform or oversee another's performance of each of the duties and functions listed, including all types of arrest, in at least some circumstances, or they have the power to do so. And this concept of having the power to do so, the ability to do so, was also referenced in 2022 presentation to the Commission when the Commission adopted the construction of the scope of Chapter 6E. And also the Commission will presume that such an official in a sheriff's office is empowered to perform all those duties and functions unless it receives sufficient information from the office showing otherwise. That's also consistent with the concept that was referenced in 2022 when this came before the Commission. The guidance then would further make clear that the regulation that I referenced earlier prohibits anyone who falls within the definition of law enforcement officer from engaging in any of those forms of conduct without having an active certification and having the authority to do so. So again, that prohibition is already in the regulation. This would really elaborate on that by providing further explanation of what is meant by police duties and functions. In concluding, I want to say again, we welcome feedback on the proposed policy from inside and outside the Commission. And in particularly, we would like to hear from sheriffs and their association because they are very directly impacted by this. And we've had communications with them over the years about this subject, and we value their input and want to hear more as this continues to be developed. And then we'll take that feedback from them and from any other members of the public into account. We wanted to give all members of the public equal opportunity to comment on this at the same time. And we'll take all of that into account and then look forward to returning to the commission for a vote or for any other action that the commission chooses to take when the time is right for that, when that process of incorporating feedback and further development has been given sufficient attention that we can feel comfortable coming back to the commission. So with that, if the chair would like, I can entertain any questions.
Does anybody have any questions or comments as to what? Don't think I see any hands in the air. Thank you very much. I know I speak for my fellow commissioners, Randy and Annie, and thanking you for the presentations today and those who have worked with you on the information. And I think with that, there are no matters which were not anticipated by me at the time of posting, and I would at this point entertain a motion to adjourn.
So moved.
Is there I don't think I need a second, right, Randy?
Right.
All right. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Hall,
Yes.
Commissioner Kesrosian,
Yes.
Commissioner Talley.
Yes.
I'm also a yes. Thank you very much. The meeting is now concluded.